A revolution in the justice system of India has come to light with the arrival of three new criminal laws, namely the Bharatiya Nyaya Sahita, the Bharatiya Nagrik Suraksha Sahita, and the Bharatiya Sakshya Adhiniyam. The well thought out new provisions are drafted to meet the present needs, but some provisions also attract criticism. July 1, 2024 is an important date for the Indian justice system as three new criminal laws have come into effect. These three new criminal laws are set to replace the existing Indian Penal Code (IPC), the Criminal Procedure Code (CRPC), and the Indian Evidence Act, respectively. Today, Global Window takes you for an exclusive interview with C.T. Jamir, Senior Advocate, President, High Court Bar Association, Kohima Bench. So, sir, how does the removal of sedition as a crime impact freedom of speech and expression according to the three criminal laws now?
In the democracy, the freedom of speech and expression is one of the most important feature. It is the hallmark of a democracy, democratic system of government. Now, earlier, when sedition law was there, the citizens, if a citizen criticized the government or writes something against the government, then they are penalized. This sedition law, I believe this was inserted during colonial period, and if we look at the laws which was framed during the colonial period, it is more authority oriented, government oriented, in the sense that it will impose penalty and punishment to the defaulters and accused persons, and the government will always have an upper hand to punish the citizens. So when sedition law was there, so many people were arrested under this law, under this provision, and then penalized. I would like to cite one example. About 2 years back, Binod Tua, who was a journalist in the NDTV, he was arrested for speaking and writing against the government during the COVID-19 regime, for not implementing the proper policies. So he was arrested for raising a few issues against the government, and he was punished under this law. But now, in view of removal of this sedition law, now people can express freely and write freely about the policies of the government, and rather it will help the people in more to express our views in a more transparent manner. So it is a good thing that the new law has deleted and scrapped this sedition law.
New inclusion of the three criminal laws, we have also seen that FIR, the way we file the first information report, has
Correct.
also been changed. So can you give us more detail about it, sir?
Yes, that is a very important question. In fact, earlier, when you want to file a FIR, you go to the police station with an application, a copy of the FIR, and then submit it into the police station. But then now, even without going into the police station, you can file an FIR. So it has become very convenient and easy for the citizens to lodge an FIR, even without going to the police station. That is in view of the technological advancement that we are getting the benefit, and the law has been framed accordingly. So I think it is a good provision that the new law has brought relief to the citizens.
So now moving on to BNSS, which is the Bharatiya Nagrik Suraksha Sahita. The first question being, how will the 30-day timeline for investigation, trial and judgment be practically implemented?
I have doubt, because the police will take its own time, and then to get some medical report, for instance, the offense of rape. Medical examination is very important evidence. Now it will go to forensic examination, and then it will go to the expert hand and all these things. So it will be very difficult to implement within the stipulated time. Of course, the object is not bad. To conclude the trial at the earliest should be the objective. And in fact, I believe the lawmakers have also kept that in mind, to conclude the trial at the earliest. Because over the years, there has been complaint by the litigants for delaying the investigation, trial, and conclusion of and the pronouncement of judgment. All these complaints were there. But then now, in the new provision, in the new law, that timeline for investigation is also given, and then the framing of charge by the courts, by a court of session, it within 60 days it has to be done. So, and then thereafter trial will commence, and then even for pronouncement of judgment, after conclusion of the hearing, within 30 days the judgment is to be pronounced. There are cases where I have experienced personally that after conclusion of the hearing, it took more than 1 year, sometimes 2 years. There are even cases which have taken more than 3 years after conclusion of the hearing. But now, within 30 days of the conclusion of the trial hearing, the judgment will be pronounced by the court. And if it is not done, then it is extended to 60 days. Another
60 days.
Yes, 60 days. So during that time, everything has to be concluded. So what practically there may be, it will be very difficult for the courts as well as the investigating agency to conclude the trial within the stipulated time. But why not make a trial? That is what I feel. Because people wants to get the justice as early as possible.
Yes.
Because the probable saying goes that justice delay is justice denied.
Yes.
But at the same time, we can also think that justice hurried is justice hurried. That is also but without compromising with the delivery of justice, I think we can give a try.
How will the attachment of property and proceeds of crime be enforced, and what are the appeal mechanisms?
If we look at the provisions, I'm not very thorough and detailed in this, but then movable properties, it talks about the attachment of properties. Movable properties can be attached, but then there are immovable properties also. There may be cases like that, and the provision is not that very clear on the immovable assets. For example, land, all this, how it has to be done. The provision is not very specific on those areas, which needs to be improved, I feel.
Now, regarding PNSS again, what are the new laws to minimize the volume of pending cases?
There are different types of offences. There are some offences which are punishable with death, punishable for life, entire life. But there are petty offences where the punishment is 3 years imprisonment and less than that. These are petty cases. Those cases can be disposed of in a summary trial. There are cases where a thorough trial can be conducted, which will take a long time. But in summary trials, like petty cases, like offense of small thieves and all that, but crime is a crime. So it has to be decided in accordance with law. So for deciding, and most of the cases are like that. There are mounting pendency of cases in different courts in the country. Even in our state also, there are so many cases pending which are petty in nature. So those cases can be decided by way of a summary trial. The offences which are less than 3 years, by way of a summary trial, the cases can be decided. So by doing that, I believe 40% of the cases in the trial courts which are pending can be minimized. That will be a good step to look forward also.
So, sir, now moving on to BSA, which is the Bharatiya Saksha Adhiniyam. So, what are the specific guidelines for admissibility and authentication of electronic evidence?
To start with, towards the beginning of the Act,
Okay.
the definition clause are given, and most important one which I have noticed is documents, the definition of documents. Earlier, Indian Evidence Act 1872. There the documents, definition of document is explained. What are the documents to be admissible for evidence, like that. Now, earlier we had only this black and white in the paper, the documents, produce the documents, and then you try to prove the case like that. So those are admitted by the court as evidence, so as to decide a particular case. But provision was not complete about evidence by digital means, for example, video recording, and then records in the mobile. All sorts of digital recordings were not admitted earlier as treated as a document, but those are also included to be treated as documents, so that those evidences can be used during the trial to prove the case. And the definition has been, in short, the definition has been enlarged, giving in view of the technological advancement in the field of digital world. So many things have developed. So all these things have been brought in and then included in the documents, definition of documents, so that those documents can be admitted as evidence during the trial.
So, just a question in between that, sir, that there are certain situations when we can tamper the evidence. So, what if in case of digitalization, when we use videos as evidence, what if someone can tamper that and present that to the court? Will that still be considered as evidence, or there can be more inquiry regarding that with the help of cybercrime and all?
In any law,
Okay.
there are merits and demerits.
Yes.
So even for these electronic recordings, there is chances of tampering the
Yes.
evidences at one stage or the other. Now that recently we are saying about question paper leak and all these things, those things may be there. But then there are so many devices also at the same time which can take care of all this tampering and all that. So technological advancement has got both merits and demerits at the same time. But then if we use it usefully and properly, then such things may not happen. And I believe the law enforcing agency will evolve some devices so as to curb such practices also.
Okay. So now moving forward again, how will the digitization of records impact the efficiency and accuracy of legal proceedings?
That is very difficult to answer. But for example, for filing of documents, when the documents are voluminous and which is very difficult to file, then in such cases digital filing is also permissible. Secondly, for examination of forensic experts and all this, when the offense is punishable more than 7 years, then it is mandatory that the forensic expert's opinion is required. So those things have been included in the new law.
What training and resources will be provided to law enforcement and judiciary to effectively implement these 3 criminal laws?
Well, actually, as I said earlier, when a new thing is introduced, so many new things are expected to be done and expected to happen also. So for the law enforcing agency, as you are asking about that, since it is a new provision, a training is required.
Yes.
Even for lawyers, we have started our schooling to study about the new law, because we do not have the magical power that such law will be passed after so many years and then I should be acquainted with all these laws. So we need to study. And in fact, many lawyers are working very hard so as to get acquainted and familiarized with the new law. Since it is new to all of us, not only for the lawyers, even for the police, who are the law enforcing agencies, and then administrators also, they should know, they should be aware of the new provisions. Therefore, from time to time, the government should organize the seminars or symposium and then the workshops, so that people will get acquainted. And in fact, about a few weeks back, maybe last month, I have seen in the paper that Nagaland government has also conducted some training to the police officers to get acquainted with the new criminal laws. That is a very good step the state government has taken, and we expect that more and more in the days to come. Not only the law enforcing agencies, administration, and for the lawyers also, we should be acquainted with the new provisions.
Also, how will these laws impact vulnerable populations such as women, minorities, and marginalized communities?
I can say that the new law is more oriented of women and children's oriented, marginalized section of people.
Okay.
Because the punishment, the quantum of punishment has been enhanced.
Yes.
For the offenses committed against the women, and then offenses against minors and people underprivileged. So the law is coming forward to extend more help towards to protect more on the rights of women and the children. So it is more friendly law for the women and the children. And the new law has given a stringent punishment to against the offenses, against the accused persons who are committing this kind of offenses.
Okay, sir, in addition to that question,
Okay.
one more question is, we see so many laws that are protecting the minorities, women in general, and the minors in general. So now there are certain cases in India where men are also victims of rape or domestic violence. So are there any such laws that protects the men in general?
I have not came across about a specific provision which protects men, but all the laws are made for the public, citizens.
Okay.
So whatever law has been made, the protection of men is always there, and anybody who violates the law is liable to be punished. But it's not that this law is meant only for men,
Yes.
but then the women and the children are more vulnerable, and then they need protections. So the lawmakers have given more importance for the protection of rights of women and the children, and that is the need of the day also. And over the years, Supreme Court has been passing, and the different high courts have been passing orders for protection of women and children, like that. So keeping in view of all these judicial pronouncements, all these rulings given by the court over the years, the new law has evolved that yes, we need a law to protect women and the children, to protect properly. So the new law has taken care of all this.
Gender neutral law.
Yes.
Okay. So now we see that with these 3 new criminal laws that have been passed, we see that there are so many challenges, or maybe there are so many controversies surrounding it. So what is your say on that, and how do we go about with implementing all those laws?
Okay. As we all know, India is a vast country with huge population, the largest population in the world, populous country in the world. Therefore, there will be lots of reactions for or against. That is common everywhere. When a new law is passed, then definitely there will be some people who will say that no, this should have been done in this manner, this should have been done in that way. So there will be so many different opinions from different corners. But then when a law is made, bill is first introduced, and thereafter discussion will be held. Again, it will go to the Lok Sabha. There also discussion will be there. So before that, a committee will examine, and then after a lot of stages, it will come into a law. For example, before framing up this law, the Bar Council of India has circulated to all the bar associations to give our views, opinion to the bar councils, bar associations, and then the different organizations, the bar associations have given their suggestions and opinions. There were questionnaires also. All these exercises have been done. So after this, the new law has come. So when a new law is made, definitely there may be some lapses here and there, small lapses will be there, but then there is always scope to get it amended also, get it replaced, changed. So like that, there may be some areas where the law has not taken care of some areas, and then there is chances of overreaching, overdoing something. But then in due course, hopefully things will be normalized, and then it will come to normal. That's what I feel.
So now, sir, with all these new laws being forwarded, what are the new penalties for gang rape and mob lynching?
In short, the penalty, the punishment has been enhanced. So it is life imprisonment and death. That means death penalty may also be imposed in certain cases. So in short, the penalty has been enhanced. The stringent punishment has been imposed against this mob lynching and the offences, gang rape and all that. These are heinous crimes. So the proportionate penalty punishment has been given. And in the new law.
So now, sir, we are coming towards the end of this discussion. So with last question here being that with all these new changes now focusing on police custody. Now people are saying that it is a cruel act since the number of days has been increased. So how do we go about with this new changes in the police custody?
I say also.
Yes, people are often saying that the police might take chances since the number of days are increased and also.
When accused person is arrested by police, they interrogate the accused persons in the police custody, police station, thana, and then they seek permission from the court, remand. And then after the magistrate pass an order, they will interrogate. Earlier it was within 15 days interrogation, police custody, and if it is not completed, then the accused persons are being sent to jail like that. But now the period of police custody has been increased by the new law. Then it will increase up to 60 days, up to where the offense is to about 10 years like that. Lesser high, but then not much. But when the offenses are heinous crimes, then and the penalty and punishment is for imprisonment for life and then death penalty like that. In such a situation, the period has been extended to 60 days and up to 90 days. So when the period of police custody is given a long period, and of course the people will have apprehension that for nothing, for no reason, the police may also, in order to extract more information, in the name of extracting more information, investigation have not been completed, so they may seek remand from the court, and they seek permission from the court that no, investigation is still going on, so we need more time. Then there is chances of misusing and abusing, and then it may ultimately it will go against the accused persons like that. In some cases, hopefully they will not do that, but then we never know. In some cases, there may be cases where the police may take advantage. The investigating agency may misuse such a long period that in the name of non-completion of investigation, they will seek for more custodial like that. So the people's apprehension is that the new law will be misused by police. So that is the apprehension that people are expressing. But then let us see, and we expect and we hope that the police will also act in accordance with law without resorting to any kind of misuse and manipulations.
Thank you so much for having us.
Thank you.
Looking for perfect summer internship? Emporium Skills Training Institute has you covered. Join our exclusive program tailored for 5th semester college students. Get hands-on experience in customer service management and industry exposure. Develop crucial team building skills, refine your grooming and personality, and master soft skills essential for any career. Prepare for your future with interview training and much more. Unlock your potential with Emporium this summer. Apply now and take the first step towards a successful career.